The FT has published a detailed story on non-disclosure agreements (NDAs) with Allen and Overy, the Focus, for having represented Harvey Weinstein during a sexual harassment claim. Of course, Harvey W. is as entitled to legal representation as the next rich, white male, and NDAs are a common practice where unsavory allegations are made. Compare the hacking allegations where MPs were outraged with the idea that silence could be bought in such a way. There are, however, one or two unusual features of the case which merit attention. The FT reports this about the clauses. One of the clauses of the NDA says that if any criminal legal process involving Harvey Weinstein or Miramax requires her to give evidence, she will give 48 hours notice to Mark Mansell, a lawyer at Allen and Overy, before making any disclosure. In the event her evidence is required, she will use all reasonable endeavors to limit the scope of the disclosure as far as possible, the agreement says, adding that she will agree to give reasonable assistance to Miramax if it elects to contest such process. It would be interesting to know how standard such clauses are, seeking as they do to inhibit any police investigation. For me, they raise the question as to whether they are intended to pervert the course of justice. According to CPS guidance, the offense is committed where a person does an act, a positive act or series of acts is required, mere inaction is insufficient, which has a tendency to pervert, and which is intended to pervert the course of public justice. One does not have to show an actual perversion occurred, and the offense plainly applies to police investigations. Indeed, any act that interferes with an investigation or causes it to head in the wrong direction may tend to pervert the course of justice. Very intimidating, he said.